Welcome to the Confidentiality Training provided by Kentucky Valley Education Cooperative. My name is Brenda Combs, and I'm going to be presenting this training to you today. If we search the word confidentiality in the dictionary or on your cell phones or whatever electronic device that you have, it tells us that it is a state of keeping or being a secret or private. Therefore, there are actions that we must take to ensure confidentiality of students' information. School personnel must protect all personally identifiable data and records collected, used, or maintained by the agency, which is you, the school district. Confidentiality requirements also apply to discussions about a student and the student records. So not only the records, we're talking about discussions that you may have. We have a definition for the term confidential, and we just sort of said that earlier in our slides. But on this one, it actually goes into a little bit deeper. It talks about if we're not at school, like we have been in the past due to this pandemic, there are other ways that we have to make sure that we are making sure the students' information is confidential. So therefore, if we have meetings, if we have video conferences, you're talking about internet, you're talking about electronic information, telecommunication, any type of technologies that the students are using that may not be physically in the classroom, we have to make sure those are confidential as well. Okay, we do have laws and regulations that ensure that we do keep our student records private. And one of those is called FERPA, which is the Family Educational Rights and Privacy Act. And with that act, it came to be that we had to have a consent to make sure that the parents or the emancipated student or married student is aware of who may want their records, or they may also want to send their records themselves. So we just have to make sure that we get a consent for those records, and this act provided that. Another is our Kentucky regulations, which were revised in 2008. And then we also have the IDEIA, which is the Individuals with Disabilities Education Improvement Act, which was in 2004. Section 504 of the Rehabilitation Act, and then last but not least, we have the HIPAA, which is the Health Insurance Portability and Accountability Act. So we have these pieces, these laws and regulations and these acts that help provide confidentiality for the student. All right, now we have two slides here, I think, that talk about what are educational records. When we're looking at that, we're looking at your personal and family data, your evaluation and test data, 504 plans, progress reports, report cards, work samples, and attendance records, written accounts of the parent and teacher conferences, audio and videotapes, electronic information stored on cell phones, PDAs, databases, instant messages, and voicemail recordings. And here is a second slide that's telling us about the educational records. These include your medical records, your IEPs, which is your individual education plan, records maintained by other agencies, information the agency uses for educational purposes, discipline records, digital computer records, video, audio tapes, film, those types of things are considered educational records. This slide might be a little different where it talks about the biometric record. A lot of people haven't thought about that. So we stuck this in here just to make sure that you knew what biometric records were. And we have it defined on the slide, and it's one or more measurable biological or behavioral characteristics that can be used for automated recognition of an individual. And those things that we have listed there as examples, you have fingerprints, you have voice prints, you have your retina, your iris patterns, DNA sequence, facial characteristics, and of course handwriting. Here it tells us, what does personally identifiable information mean? And this is a list. It's not an exhaustive list, but on here it mentions the name of the child, the name of the parent, or any other family member, address of the child, their social security number, or even their student ID number. Indirect identifiers, which is, of course, the date of birth, the place of birth, and, of course, the mother's maiden name. Information that can be used alone or in combination that specifically links to that child. Characteristics or other information to identify the child. And when we're talking about those characteristics, it's like if you describe a child to a person, and I or another person can go in there and into a classroom and we can pinpoint who that child is. That is what that is talking about there. Okay, the next slide says, how does the school district ensure student information and records are kept private? So we have to make sure that we do that. One way that we do that is to have the confidentiality training. This will make sure that everybody in your district is aware that there is confidentiality, there is laws, regulations that we have to abide by to make sure that we don't break any type of breach with a student. So we have to make sure of that. So when you're looking at the slide, it tells us about this trained, the staff that is trained, and like I said, the whole entire school district, because you're looking at your school-based councils, your volunteers, your substitute teachers, your cafeteria workers, your student teachers, substitute teachers, bus drivers, your bus aides, your school nurses, and then, you, of course, you have your office staff, your custodians, and then you have your itinerant teachers. So that just about takes up everybody in your school district. So you just have to make sure that you have these people trained and in place. Kentucky Open Records statute recommends that districts respond to parents in about 3 days or less of the request, because they have to fill out a request. So your parent, your guardian, your eligible student are allowed to inspect the records. And when I'm talking about an eligible student, I'm talking about a student that has been emancipated or married. When we talk about the breach process, there are some guidelines that we have to go through to ensure that we follow the protocol that we have in our districts. And on this particular slide, we've got the district has to do an investigation. You have to report that to the KDE Legal Counsel and the Attorney General's office, because that has to be reported to the federal level. You have to contact all parties involved in that breach of information, and you have to have a plan developed to follow up and do a report to KDE Legal Counsel. And it could also be followed up by the Attorney General's office and KDE. Here are ways to protect other student records. So when we're protecting those, we must, when receiving and to review grades, we're looking at grades that cover students. So what we do is we want to make sure we don't show parents or the emancipated student, guardian, whoever. We want to make sure we cover up the other kids' grades, because we don't want them to see the other students' grades. Right now we have Infinite Campus. We can actually print off student grades using that. That way it will not show other students' grade, which is probably better. So we have to make sure that they do not see the other students in the classroom see their grades. All right, when we're looking at discipline records, we do not cite other students' names that might have been involved in that particular incident. So we just leave that be and not discuss the other student. And the parent wants to ask you that particular question, well, who was the other student? All you can say is, this is confidential information and I'm not allowed to provide that. Okay, when speaking to the parent, just make sure you don't mention the other students' names or any of the other parties that might be involved in that. Do not discuss other students' names in a meeting. Sometimes in ARC meetings, you may be asked about other students and they may say that a certain student's getting this, that, or the other type of accommodations or something. Why is your child not getting that? You can't answer that. You just have to remind the parent that this ARC meeting is about your child and you are not allowed to speak of any other child. Do not discuss any other student in the grocery store, at ball games, or in church, or anywhere. Just don't talk about other students. Even if the parent comes up to you in the grocery store, do not talk to them about the student. Just give them a time for your planning time that they can come in and talk to you about that particular incident or whatever they want to talk about. Do not talk about it in public. You never know who's on the next aisle listening to you. Okay, and here is continued over about the information about their child. So when you have the teacher-parent conferences, do not share confidential information during that time. Even if it's a niece or a nephew or that type of situation, unless you are the guardian of that child, they're not allowed to get that information. It has to be from the legal guardian or parent that you give the information to. And each school must decide how to document the parent conference and the method for storage of that, because you have to have that if it's ever asked for, if you have any kind of legal matters. Faxing information, we have to make sure the fax is marked or stamped confidential information, and it usually has a little disclosure at the bottom of it. If you're not the person, then you need to delete it, those types of things. So we just have to make sure that we send it to the correct fax number and that we do mark it or stamp it confidential information. All right, so here are some best practices. And, do not include student or teacher names or grades in the email. And when you're doing an email, you also need to put that confidential statement in there, so in case it did go to another person, that they would know what to delete it, those types of things that it tells you to do in that statement. Because remember, an email is public record, and it can be forwarded without your permission, and it can also be subpoenaed if there's a legal issue, if it was to arise. Do not give any information over the telephone, because you don't know who's on the other end of the phone. You cannot see them, so you cannot always identify that person on the other end of the line if they are the legal guardian or parent. Here is that confidential statement that you can put as a disclosure on your fax or any other document, email. That you can do. It says this electronic mail transmission is for the use of the named individual or entity to which it is directed and may contain information that is privileged or confidential. It is not to be transmitted to or received by anyone other than the named addressees or the person authorized to deliver it to the named addresses. It is not to be copied or forwarded to any unauthorized persons. If you have received this electronic mail transmission in error, delete it from your system without copying or forwarding it, and notify the sender of the error by replying via email so that your address record can be corrected. So that is the little statement that we had on there, and that's what you can copy that and use that as your own. So we have some issues regarding electronic information, and as you know, this world is a technology world. Not that I'm the best at it either. I'm learning, but I'm getting there. But anyway, there are some electronic information that we need to know about, and we always need to refer back to the FERPA's definition when we're using that technology. In this one, the contents of personal electronic devices may prove to be very embarrassing and provide information that can be used against the school district or you. Consider FERPA's definition when using your cell phones, voicemail, recordings, texting, Facebook, or any type of technology. We just have to remember to follow those FERPA guidelines. As educators, we must make sure we identify records that are confidential. And like I said, you have a stamp, or you can write on there, confidential. In our filing cabinets, we actually put on a list of who can actually see, like, special education records, who can view those. And we have it in a locked filing cabinet to where that can't be opened, only by the teacher who has access to that, the key to the filing cabinet. So confidential information is like lesson plans, report cards, your individual modification plans, your behavior plans, IEPs. If you have a substitute folder that has the IEPs, those types of things in there, it has to be marked. It has to be put in a place that no one else can view it. Therefore, it will not get out. If you have a folder laying on your desk, it can always be picked up by someone, and it could be picked up by an accident if they have something laid there and they just actually pick it up. So we just want to make sure that it's just not laying around somewhere. Make sure it's in a safe place. Unprofessional versus professional sharing of information. When talking to a colleague or a student or his family, applies to these 4 questions. So there's 4 questions that you must think about prior to answering someone's question to make sure that you're not violating that student's rights. And the next slide will tell us those 4 questions. It's what is discussed, where the discussion takes place, who is listening, and why the discussion took place. So we have to make sure that this discussion that we're talking about is beneficial. It's not just to be talking per se. We just have to make sure there is a reasoning behind this, and the reasoning is for the better of the child. Who can access student records? You have parents or the student representative. We have to complete a document to make sure that the student representative is a legal guardian, a foster parent, of any sort of a parent, whatever, and we'll talk about a parent in a few minutes, the definition of that. A student who's 18 years old that is emancipated, authorized employees of the district, staff from the United States and State Department of Education. And then we have to make sure that we have access of a recording document. So if I was to go into your district, I would have to sign a document. I would have to put the date. I would have to put my name, where I'm from, and why. What is the reasoning for me to be in a child's folder? So you have to keep that documentation in case it was to go to court. We have to have those types of things to show that I did have access to that folder or information. Okay, so we've had questions before about divorced parents and surrogate parents, all these types of questions. So this one here is, do guardians, divorced or separated parents, foster parents, and surrogate parents have the right to review a child's record? Well, both parents have the right to review their own child's record unless you have a court order stating that the educational rights have been removed. If you have joint custody, yes, they can view the records. Again, just make sure that both parents have access, and their educational rights have not been removed. Foster parents, they have a right to review the records, but they can't make any educational decisions unless you have documentation from the court showing that they have permission to do so. Parents can request interpretation of records. Therefore, if there is something in a document that they have no clue or they don't understand what it means, then they can ask for an interpretation of the records, and then you can go in there and do that. If you have a person that is not speaking English and has problems with that, then you have to provide an interpreter to interpret those records. Okay, conditions where prior consent is not required. It's a disclosure within the agency with legitimate education interest. Sometimes you will get a pamphlet from the school, and it talks about taking pictures and all these types of things. And if you give them permission to do so, to put it in the newspaper or put stuff on the radio, then the parent can give permission for that. That way there'll just be one document, it's signed, and that way they can put those pictures in there. A lot of times the athletic students are involved in this, and then of course you have your other teachers that enjoy putting things in the paper about their students and some of the projects that they do. So they have this disclosure for those parents. Officials of another school system or institution of post-secondary education where the student seeks to attend or enroll. So if you have your graduate students or your seniors that are graduating and they may choose to go to a certain college or university or even a technical vocational school, there could be pieces of information that can go along to them without having to have all this paperwork. Your directory information, audit purposes, and of course subpoenas or court order, we have to abide by those. Financial aid, and then you have your health and safety emergencies. Parents are given public notice of types of information designated as directory information, and they're given the opportunity to refuse. So if they do not want their students' work, projects, or pictures in the newspaper or anything of that nature, then they can refuse as well. Then we're looking at the directory information, and of course it's the student's name, the student's address, student's telephone number, the student's date of birth, participation in official recognized sports and activities, student's weight and height if it's a member of the athletic team, dates of attendance, awards received. May a student review and inspect his or her own record. The only way a student can do that is they have to be emancipated or married. So an emancipated student is eligible to obtain access to his or her own records if they are 18 or older, or they are married. How does the school system release school records? As of now, within the state of Kentucky, we can export records from Infinite Campus. And there's other ways of doing that as well. Parents can come into the school and sign a release, and the school can then send their records to wherever they request them to be sent. But how does the school system release the school records? Your parent, your guardian, your emancipated student, they must make a written request for the release of their records to another agency or to another person. Special education students or students currently being evaluated submits to the special education department. That's normally your director of special ed. And if they're not in special ed, the written request still obtained and needs the purpose for the release. The student information may be released to the Department of Social Services. Okay, we do have a requirement that we must follow, and when you're looking at the slide, I know it's very big and it has a lot of information in it, but every employee of the Kentucky Public School District must adhere to the confidential protection of all the students. All students' information should be kept confidential unless disclosure serves professional purposes or is provided by law. Failure to do so may result in the revoking of suspending of Kentucky certification. We do not want that, so let's just make sure that we follow the guidelines. Protecting students' confidentiality is the law and also the right thing to do. Now we have some scenarios that we want to go through, and we do have the questions and we do have the answer key that goes along with this. So after each of the question slides, if you would just pause the video for a short amount of time to discuss that with your staff, and then you can turn the video back on and it will give you the answers to the scenarios. So our first question is, the Children's Corner Daycare calls a local school district and requests that Sue's school records are forwarded to them. It is a small community, and the person receiving the call is familiar with the caller. Can the records be sent under these conditions? So pause your video and have a discussion, and then once you have the discussion, turn your video back on. So the answer to scenario 1, the records cannot be sent without written parental consent. FERPA and IDEA do not allow school districts to send personal identifiable information to another agency without written parental authorization. A daycare may be providing educational activities for the student. However, they are not a state educational school district or agency. Our second scenario is Amber's family moved to the neighboring county. The neighboring school district sent a request for the transfer of records. Can this information be forwarded without parental permission? Please pause your video while you make your discussion. Okay, here is a response to scenario 2. The records can be sent to the neighboring school. FERPA requirements allow the school district to forward educational records on request to a school in which a student seeks to enroll. Federal requirements state that a reasonable attempt is made to notify the parent of the student of the transfer of the records, except when the transfer of records is initiated by the parent or when the school district includes their annual notice that is forwarded on request to another school district. Scenario 3. Jane is a bus driver at the Brownsville Elementary School. Jane's close friend asked Jane to check on the progress of a friend's nephew who also attends Brownsville's. Can Jane obtain this information? Pause your video and have your discussion. The response: Jane has no legitimate educational interest in the progress of someone's nephew. Therefore, she has no right to review his progress. In order for Jane to review the progress of the nephew, she would have to be working directly with the child, but she still could not share the information with her friend. A written consent signed by the parent is required before educational records can be released to anyone that does not have legitimate educational interest. Scenario 4. Sandy lives with her grandparents. Sandy's parents have legal custody of Sandy, but they have a very limited role in the care of Sandy. Sandy's teacher would like to initiate a referral due to a suspected learning disability. Who has the right to give written permission to evaluate Sandy for the suspected learning disability? Pause your video and have your discussion. According to IDEA 97 regulations, a parent means a natural or adoptive parent of a child, a guardian, but not the state if the state is a ward of the state, if the child is a ward of the state. A person acting in the place of a parent, such as a grandparent, a step-parent, or whom the child lives, or a person who is legally responsible for the child's welfare, or a surrogate parent who has been appointed. According to the policies and procedures for special education, the ARC chairperson determines who represents the child in educational decision-making through a review of educational records. If the ARC chairperson determines there is no parent in resident, then the person with whom the child resides as a family member, friend, or other person with whom the parent has made an informal arrangement to care for the child, then the ARC chairperson can determine that a person is acting as a parent, and as such has all the rights of a parent until the parent reappears to reclaim his or her rights. Therefore, Sandy's grandparents are acting as a parent and had the rights of the parent in making educational decisions concerning Sandy. Scenario 5. Matthew's natural father arrives at Matthew's school. He requests to see Matthew's school records. A review of Matthew's school records indicated that Matthew's parents are divorced and that Matthew lives with his mother. Can the school allow access to educational records to Matthew's father? Please pause your video and have your discussion. The answer to your scenario is both natural parents are allowed access to the educational records of the child unless the school has been informed that the parent is not allowed due to some legal action. And when you have that legal action, you must have that document, the court document, showing that. The fact that Matthew's parents are divorced does not automatically take away his parental rights. If the school does not have a legal document stating that a parent does not have access, then the school allows the natural parent access to the child's educational records. Scenario 6. Mary is a parent member of a site-based decision-making council. Mary would like to have a look at the recent state test scores of all the students in Mrs. Reed's class. Does Mary have access to these records? Pause and have your discussion. The answer is no. Mary does not have the rights to access the student's educational records. A site-based decision-making council member does not have access to personally identifiable information. Parent consent would have to be obtained from each parent to allow Mary access to the student's educational records. Scenario 7. Bonnie has recently separated from Fred. Bonnie and Fred are the natural parents of a student in your classroom. Bonnie sends you a note that Fred is not to have access to any of their child's educational records. Can the school honor Bonnie's request? Stop the video and have your discussion. Right, the answer is both parents are allowed access to the educational records of their child, unless the school has been informed that the parent is not allowed due to some legal action. So you must have a document to that effect, showing that the parent does not have the right for the educational services. So the fact that the parents are separated and the mother has requested that the father not have access does not constitute a legal action. You do not have that legal document. It's just one parent saying something and does not want the other parent to have the access. So we don't want to do that. We're there for the interest of the child and not the parents. Just remember that. If the school does not have a legal document stating that the parent does not have access, then the school allows the natural parent access to his or her child's educational records. Scenario 8. While shopping at Walmart, an adult in the community asks you, "How is that new guy in your class doing? I heard that the police came to school this week to interview him. What information can you release concerning that student?" Pause the video and have your discussion. The answer is no information can be given. So no information may be released to the community member concerning this student. This community member has no legitimate educational interest and is not accessible to personally identifiable information concerning any student without written consent from the parent. An appropriate response could be, due to confidential laws, school employees are not permitted to discuss individual students without written parent consent. Scenario 9. Your supervising teacher will be out for 3 days and a substitute teacher has been hired. He asks you to put the names of the students who go to resource and to speech on the board and their times so he can keep their schedule straight. Can you write the names of special education schedule on the board? Pause your video and have your discussion. The answer is no. You cannot post or list the student names of special education students or speech students in your classroom. The information needs to be posted in the substitute teacher folder or in the teacher's lesson plan book. Schedule reminders should not be posted on student desk. So congratulations, you have now completed your confidentiality training. I hope you have enjoyed it. I hope you have learned something. Remember, you are held accountable for maintaining the confidentiality of student information both at work, at home, and in your community. So make sure you watch what you say, and for best practice, just do not say anything outside of the school. Thank you for watching. You will now complete a quiz. Once you take your quiz and you make 80% or better, you will be sent a certificate through the email that you provided. Thank you.